All right. Good afternoon, Council. I'm thinking we might have had a little miscommunication because we had the status conference set for 1:30, and then the motion is set for 3:45, I believe. And I don't see opposing counsel, so okay. I'm wondering.
I wasn't sure. I just, out of abundance of caution, I thought maybe the hearings might be consolidated, but it obviously makes sense. But I wasn't sure which way it was going to go. So I guess I'll just see you in a couple hours, I suppose.
Yeah, I was hoping that council would appear because we could have taken care of all of it, earlier rather than waiting. But unfortunately, it looks like we'll have to wait until 3:45. And typically, the court would schedule them together. I suspect that the status conference got set prior to when the motion was filed. So.
Most likely. All right. No problem. I will log back on around 3:45.
Okay. Sounds good. Thank you.
Right. Yep, take care.
And then we also have at 1:30 scheduled Cosby versus Foremost Insurance, case number 2319354. The record should reflect neither party has appeared. That was set again for 1:30. It's now 1:38. This matter was adjourned out from April, so the court will set this for an additional hearing in about 30 days. All right, looks like we've got everybody connected, so we'll go on the record. This is Robert Kersey versus Secretary of State. This is case number 2419652. If I could just have counsel put your appearances on.
Thank you, Your Honor. For the record, on behalf of the Secretary of State, Mike Rolla from the Otsego County Prosecutor's Office.
Judge Mike Clegg, P number 79314 on behalf of Petitioner Kersey.
All right, thank you. We're on the record here today for Mr. Kersey's appeal of a denial of a driver's license by the Secretary of State. Just so both counsel are aware, I did have a chance to review all the pertinent documentation, including reading the transcript of the hearing before the hearing officer. And Mr. Flagstad, I had an opportunity to read your brief as well. As both counsel are aware, the court has to confine its review to the record, so we can't take any testimony or have any additional evidence here today. But today would be the opportunity for both sides to present an argument. Mr. Flagstad, since you're the party appealing, is there any oral argument that you wanted to make here on the record today?
Judge, very briefly, I don't want to waste your time rehashing my whole brief. But very briefly, first of all, this was the shortest SOS transcript I've ever read. Your experience might be different. I've never seen one this short. Mr. Kersey was denied because he supposedly testified he's never been sober more than 6 months, because he couldn't articulate any principles of recovery or relapse prevention strategies, because he wasn't working the community support program, and because he was supposedly unwilling to admit that he had a problem with alcohol. The problem with each and every one of these deficiencies, Judge, is that first, he never said that. We know for a fact it isn't true because he was actually testing for over 2 years after his second conviction, including on probation, and then with an interlock, and then with a sober link he got pursuant to a custody case. He was never asked about knowledge of AA or prevention strategies. It didn't happen. And he did detail a number of proactive changes that he made to avoid putting himself in a position where he would be tempted to drink, all of which were ignored by the hearing officer. The law does not give the hearing officer any authority to require community support group attendance. And he did actually participate in AA for a good period of time, which again was ignored. And then as to admitting he's got a problem, how can you ask a petitioner to ignore the conclusions of a substance use examiner? You require them to get the examination. I'm sure this court has seen results come back across the board. I've seen results come back across the board. But what this order suggests is that the results don't matter. It's irrelevant. We don't care what the substance use examiner says. If we take the hearing officer at his word, that his concern is that the petitioner just can't control himself. At some point, he'll slip. At some point, he'll have a mistake. Doesn't an ignition interlock device alleviate that concern? I mean, let him prove it. If he slips up, if the substance use assessment is wrong, then he's done. The car literally won't go. His license will be in. Judge, all we're asking for is an ignition interlock device and the chance to prove it on a restricted license. There's very little risk in the sense that a person physically cannot drink and drive with that device installed. He lost his restricted 10 years ago because he missed a hearing on a tamper circumvent violation. 10 years is long enough for a second chance. Because this decision is arbitrary and capricious, because it doesn't match the narrative or the testimony actually provided at the hearing, because it moves the goalpost, because it adds ex post facto requirements, we ask you to set it aside and give him a restricted license. That's it for me, Judge.
Thank you. Mr. Rolla?
Yes, thank you. And if we're still having, I can still hear the same audio issues that we were dealing with earlier. So if I cut out, I apologize. Thank you. A number of factors actually agree with the petitioner in this case. I could see here, and I also did read the entire transcript. I did not see anywhere where it indicated that the defendant said he could not maintain or had not maintained sobriety for ever more than 6 months. I also don't see, I also agree that he had said he had taken some remedial steps to correct his issues with substance abuse, engaging the people he's with, moving alcohol from the home, etc., as indicated in Mr. Flagstaff's brief. The only issue I think that was raised, and I think the only one that could be raised, and it would be two things. One of which is that the hearing officer did take note of the fact that there were 2 drinking and driving and a third offense, a controlled substance offense in 2015. And because of that, he thought a longer time period than the 6 months should be imposed. I don't know if that was sufficiently addressed on the record or not. Again, that's going to be up to this. The only other thing too is, as the court's aware, the burden to show that that's been met is not only the hearing officer to prove by clear and convincing evidence that the defendant or petitioner hasn't done this, the burden is to do so. So if the court on the transcript that those things have been met, then I believe the court could grant a interlocutor advice. Thank you, Your Honor.
All right, thank you. So yeah, again, I did go through the entire record, which included the other exhibits that were admitted at the hearing, which were the reference letters on behalf of Mr. Kersey, as well as the substance abuse evaluation. And then of course the hearing officer's ruling. And you know, this is, in my view, this is a very unique case. Typically, you know, the court doesn't have a lot of discretion. First of all, under the law, as I stated at the beginning, the court has to simply review the record. And as long as the hearing officer, you know, basically followed the law, applied the correct standard, court really can't insert itself into the decision-making process. It certainly can't substitute its judgment for that of the hearing officer, as long as that decision is based on material, substantial, adequate evidence on the whole record. And this is a case where I really do feel like this decision was arbitrary and not based on the evidence. And just reading the findings of the hearing officer, I almost feel like there was something personal there. I don't know if he didn't like the way that Mr. Kersey kind of appeared or came off at that hearing. But, you know, I've been on the bench for 11 years. I've done a lot of these appeals. I've not seen one where I really felt like the hearing officer just didn't want to give the applicant an opportunity. And I really feel like it was that way. And I think that comes through in the transcript too. I mean, I feel like reading that transcript, Mr. Kersey seemed to be very upfront and very candid and honest about his use of alcohol, both at the time that it did present a problem for him legally and since then. I thought his testimony was very consistent with the findings of the evaluation. And, you know, after the amount of time that's gone by since the last conviction, and even since the last restricted license situation, it's one of those things where I just don't know what else Mr. Kersey could possibly do to satisfy this particular hearing officer. And, you know, the amount of time that's gone by without him having any issues with driving on a suspended license, with any kind of alcohol related contacts or any contacts really since 2015 with the criminal justice system. We're at 2024. I don't know that the passage of more time is going to help anything. And I think at this point, Mr. Kersey frankly does deserve a chance at a restricted license. And I think he's demonstrated that. And again, I think the hearing officer's conclusions just were not consistent with the record. So the court is going to reverse the decision of the hearing officer. The court is going to grant the restricted license under the terms requested, as Mr. Klagstad indicated. And so, Mr. Klagstad, if you can prepare an order that reflects the ruling of the court and any other orders that the court would need to enter in order for Mr. Kersey to get his restricted license.
Absolutely, Judge. And just from my experience, it seems like the easiest way to do it is I submit it to Mr. Rolla first. If he agrees that it, accurately reflects your order, then I present it to the court and we go from there.
Okay, very good.
Thank you.
Anything else that we need to address for the record from your side today?
No, Your Honor, thank you.
Mr. Roll, anything further from your side?
Just to Mr. Claggs, office wants to send it in an email. I can confirm and sign with permission, and then he can forward it to the court.
Sounds great.
I do have another question to the court, though not on this matter, but I see on the docket a hearing scheduled for 3:30 on Adkins, Michael Duran Adkins, and it's a application set aside, but I don't see it. We didn't get a hearing notice on it, so I didn't know if the court still has that on its docket or not.
Yes, it is on the docket.
All right, very good, Judge.
Okay, thank you. All parties on this file are free to disconnect at this time.
Thank you, Judge. Thank you, Mr. Roll.
Take care.
Okay, looks like we have everybody connected, so we'll go on the record. This is Bradley versus Tackett and Tackett versus Tackett. The first one is case number 2319551, and the second is 2319555. These files have been consolidated for the purposes of discovery, and we're set for status conference in each of these files today. So just starting with the plaintiffs here, Mr. Wall and Mr. Post, can each of you kind of give me an update from the plaintiff side about where we're at and what we might want to do here today going forward?
Thank you, Your Honor. It's my understanding that the other plaintiff has settled at mediation. Our mediation did not settle, so we are still looking to move forward to set discovery dates. We just secured a date for depositions, and I think that'll get the ball started on our side.
Okay, Mr. Post.
Yeah, thank you. That's correct. We were able to resolve and settle our case at mediation just a couple days ago. We don't have a release signed yet, but that's obviously the next step. So I would anticipate a release and dismissal to be coming your way in the next few weeks.
Okay. All right, Mr. Friel, then, as to Mr. Wall's file, what would you like to see going forward here?
My only issue is that I have 3 jury trials in September and October that are going to be fairly lengthy, so I just want to make sure we have enough time. I agree with everything Mr. Wall said. The next step is to get some depositions. I just want to make sure I'm realistic about that. So we're going to need probably a month and a half or 2 months, or at least to get through the end of October.
Okay. Are either of you anticipating any dispositive motions?
I do. We are considering 2 different dispositive motions. Whether or not we go forward with those is obviously going to depend on what the testimony is, but preliminarily heading into it, it looks like 1, if not 2. One would be a threshold injury, and the other one would be that the plaintiff contributed to the intoxication of the minor driver, and what effects the law has in store for someone who does that.
Okay, so what if we set aside 90 days for the parties to complete discovery, and then the court set a deadline 30 days after the close of discovery for dispositive motions, and then set another status conference at that time? Mr. Wall, do you have any objection to that?
Your Honor, can I interject for a second?
Sure.
The case that the 19551 case, that's a Judge Hunter case. It was consolidated with this one of yours. So the 19555 case is going to be dismissed. So the 19551, I would think, would go back to Judge Hunter.
Okay.
Jen had sent an email to us on Friday to me on Friday afternoon saying that it was consolidated for discovery purposes only. So before you went any further, I just wanted to let you know before you set dates. I don't know how you want to, if you just want me to refer it to, to Chris to have her get it set, or what you'd like to do.
All right, I think since the parties are in agreement, I don't think Judge Hunter will have an objection, but what I'll do is I'll draft up what we've discussed today. I'll forward that to Judge Hunter to sign as a scheduling order, and just with a note saying, this is what we did. And then if he has any objection to that, I'm sure he'll address that with a full review. Do you guys have any objection to that?
No, Your Honor. And in fairness, I had a 2 o'clock with Judge Hunter in a similar case, and he did the exact same discovery in that case. So it's likely what he typically does on his discovery. Anyways, is a 90-day with 30 days after that.
Okay. All right. Mr. Wall, anything further that we need to address from your side here today?
Nothing, Your Honor.
Mr. Friel?
All sounds good to me.
Okay, Mr. Post, anything else from your side?
No, I'm all good. Thank you, Your Honor.
Okay, thank you. All parties on these files are free to disconnect at this time.
Thank you.
Thank you, Your Honor.
Okay, the parties for the 2:30 hearing, you can hear me. This is Judge Mertz. I need you both to connect your microphones and your cameras and to turn that all on. I can see you're here in the waiting room or in the Zoom courtroom, but I need to be able to communicate with each of you. All right, sir, I need you to unmute.
Gordon.
Ma'am, are you there? Can you tell me your name, please?
Mary Dingy.
Miss Dingy, okay. Mr. Dingy, are you there?
I can't get video on. It won't allow video Zoom to undo the camera.
Just click OK.
Are you both on the same line?
I can't get my video to come up for camera.
Are you both on the same line though?
No.
Okay. All right, so the male voice that I hear with you, that's not Mr. Dingy?
No, sir.
Okay. Okay, if you can just hold on for a minute, Miss Dingy, I'm gonna see if we can get Mr. Dingy to be connected here. Mr. Dingy, can you hear me? Mr. Dingy, can you hear me? All right, it looks like Mr. Dingy's having trouble connecting and operating his Zoom camera and microphone. So I think I'm gonna have to reset this hearing. But Ms. Dingy, can you just tell me from your standpoint, the purpose of this hearing was to set some dates for scheduling to get your divorce finalized.
Yes, sir.
And one of the questions that I have for both of you is whether or not you've been able to reach any agreements.
Yes, we have.
You have, okay. So what I can do is set this for a final hearing, and at that point, we'll be able to, as long as you guys agree that there aren't any decisions the court has to make in terms of dividing things up, then we can finalize things at that next hearing, okay?
That'll be fine.
All right, and I'm gonna set that as an in-person hearing, given the troubles I think that both of you had here a little bit in terms of utilizing the Zoom, okay?
Okay.
So you'll get notice of the date and time of that hearing from the court, and that'll be sent to you by mail, and we can finalize things then. Do you have any questions at all?
No, sir, I do not.
Okay. All right, thank you. You're free to disconnect at this time.
Thank you.
All right, and then we also had set at 2:30, Culbertson versus Culbertson, case number 2419562. Neither side has appeared on that file. That was set for entry of a default judgment of divorce. The court will reschedule that one more time. Neither party appears. The court will simply dismiss that case. And the next hearing is set for 3 o'clock. Recess until that time. All right, Mr. Bryant, if you can unmute, please.
Can you hear me?
Yes, I can. Thank you. And Ms. Bryant, if you can unmute.
I did.
Okay, great. We're on the record now. And this is Bryant versus Bryant. This is case number 2419724. The record should reflect that both parties are present today by Zoom video. I have here in the file a proposed judgment of divorce that you both have signed. Ms. Bryant, did you want to go forward and finalize the divorce today?
Yes.
All right, and Mr. Bryant, is that how you'd like to proceed as well?
Yeah.
Okay. In a moment, I'm going to have both of you raise your right hands, and I'm going to put you both under oath. I've got some questions that I need to ask each of you. The questions that I'm going to be asking are those that I'm required to ask to establish the grounds for divorce under Michigan law. So if you both please would raise your right hands. You both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Yeah.
Thank you. You can lower your hand. Ms. Bryan, as the party who filed for the divorce, most of my questions are going to be for you. My first question is, you filed a complaint for divorce and you signed that complaint. Is that true?
Yes.
At the time that you signed that complaint, had you been a resident of the state of Michigan for at least 180 days?
Yes.
Had you been a resident of Otsego County for at least 10 days?
Yes.
In the complaint for divorce, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true when you signed that complaint?
Yes.
Does that remain true today?
Yes.
Are there any children who are under the age of 18 that were born to or adopted by you during the marriage?
No.
Are you currently pregnant?
No.
Under the judgment of divorce, you would not be receiving any alimony or spousal support. You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that.
Yes.
And have you and Mr. Bryant agreed on how to divide up all the assets and debts of the marriage?
Yes. The only thing that we have not agreed on is some debt to a credit card that he put on my credit card is the only thing.
Okay. Are you agreeing to finalize the divorce without that having been taken care of?
Yes.
And you said that that's in his name?
It's in my name. It's a credit card that he used to purchase tires for his truck and some other things for his truck.
Okay, so you understand that if you're not able to make any agreements about that, that if we finalize the divorce today, that is going to remain in your name and you won't have any legal recourse against him.
And what if I don't agree to that?
Then we can't finalize the divorce today, and the two of you will have to reach an agreement on that before we finalize the divorce, and it'll have to be written in this judgment.
I'd like to do that because I'd like to not have to be responsible for that. I have a 6-year-old son that I have to take care of, and I just don't have the extra money to pay for what he's put on my credit card.
Okay. All right. Mr. Bryant, were you able to hear what we've been saying there?
Yes.
So the only thing that we could do here today to move forward is if the two of you reach some type of agreement here on the record, and we put that in writing, which I can write into the judgment of divorce. So I don't know if that's something, do you want to have a chance to talk to her about that before we end the hearing today?
Yes.
Okay, I'm going to place both of you into a breakout room so that you can have a private discussion about that. I do have another case that's set for 3 o'clock, so I'm going to take that case while you're doing that. And if you're able to reach an agreement, we can write it down and finalize the divorce. And if not, then likely the next step would be the court would have you participate in mediation where an independent third party would try to facilitate an agreement between you on that. So But for now, I'm going to put you into a breakout room so you can talk privately off the record about it.
Okay.
Okay.
So I'm doing that right now, and you'll see something on your screen to go into the breakout room.
Good afternoon.
All right, good afternoon. I just need all the attorneys to connect and unmute. And Mr. Barrett, you're here on behalf of plaintiffs, is that correct?
Yes.
And Ms. Mott, you're here on behalf of the Mager defendants?
That's correct.
And it looks like Ms. Cristoforo is connecting, so if council can just hold on for just a minute. Looks like she was connected for a minute, so she might be having some technology issues here. So if council can just wait, she's trying to sign on again. All right, Ms. Cristoforo, if you can unmute, please. Thank you. Okay. Hi, thank you. We'll go on the record now. This is Waiterman et al. Versus Mager et al. Case number 2419714-CH. We have Mr. Barrett present by Zoom on behalf of the plaintiffs, and we have Ms. Cristoforo. You're appearing on behalf of yourself and Mr. Barry, is that correct?
Yes, Your Honor.
Okay, and then Ms. Mott's here on behalf of the other defendants. We're on the record here today for purposes of a scheduling conference. I was able to review the pleadings, so I kind of understand the nature of the claims here. In terms of going forward, Mr. Barrett, addressing you first on behalf of plaintiffs. Is there any particular period that you'd like for discovery? Do you think that an early mediation in this case might be something that the parties want to participate in? Can you kind of tell me where you're at in terms of how we want to move forward?
Yes, thank you, Your Honor. I don't see a lot of discovery necessary for us. I have a couple of items that I would probably send out. And in terms of mediation, I think we could probably start mediation right away if everybody's in agreement. I know my clients are happy to do so. And if this discovery got complicated in any way, I think that we could pause mediation, but I don't foresee that to be a real problem.
All right, and is this a case where, and I'll address the defense counsel as well, but is this a case where you would want an attorney, facilitator, mediator, or
yes?
mediation? Okay.
Yeah.
Okay. Ms. Cristoforo, what are your thoughts on how we want to move forward?
Mine keeps cutting out. I'm only hearing about half of what's going on, so I apologize if I just missed about part of what Dan said.
Okay.
Oh.
He's suggesting utilizing a facilitator, attorney mediator, as opposed to something like community mediation.
Okay, I'd be fine with that.
Okay. Ms. Ma?
No objections as to that. I do have one issue to raise, which is that my clients have made an insurance claim. So I am not certain that I will remain as counsel. So that could just create a little bit of a problem for today's purposes, but we can certainly set deadlines, and then that new attorney can raise that issue if they need to.
All right, so typically the way that I do scheduling, I don't set dates for the entire case going out all the way until a potential trial. I like to set some initial dates to get things moving and then kind of adjust it as we need going forward. So my suggestion would be to set an initial period of 90 days for discovery to remain open with an order that the parties are to participate in a mediation session within that period of time. And then I would set this for a status conference, about 90 days out to see where the parties are at. We'll meet just like we're doing here today by Zoom, and we can set further dates if mediation hasn't been successful. Mr. Barrett, do you have any objection to that time frame?
I do not. I would say that with respect to Ms. Mott and her client, I don't think that they've responded to initial disclosures yet. So I'm not sure that, anybody's stepped in anybody's way to the extent that there might be some kind of counsel coming in from an insurance company. Would welcome them.
I filed them. And end of July 18th.
Oh, I didn't get
I'm
any
sorry.
either.
Okay, I'll check on service.
I'm sorry, I missed what you said. What's
July 18th. So I will I'll resend them by email if you didn't receive them. But yep, I have them done.
Oh, okay. And what do you know about the insurance company coming in?
I don't know anything, really. I talked to my clients today. They said they made a claim recently. That's all I know.
I imagine you'll keep us in the loop.
Certainly. Yeah, I imagine I won't be the attorney, so I'll certainly keep you in the loop.
Okay. All right. I did have one question. I sent you an email. Was there some response to that? About,
no, no.
Okay.
All right, so for purposes of scheduling today, I'm going to, again, set a period of 90 days for initial discovery. I'll put in the status conference order that the parties are to participate in mediation within that 90 days. Also, I'm going to ask counsel to confer and attempt to reach an agreement on a mediator and then notify the court of your selection. The pretrial order will provide a selection process if you're not able to agree on a mediator, but I'm going to ask the parties to at least attempt to do that. And that'll all be set forth in the pretrial order that I'll send out to all of you, as well as the notice of date and time for that next status conference in about 90 days. Mr. Barrett, anything else I can address for your side here today while we're on the record?
No, I think that should cover our side, Your Honor. Thank you.
Okay, Ms. Cristoforo?
Nothing for me, Your Honor.
Ms. Mott?
No, thank you.
Okay, sounds good. Thank you, everyone. All parties are free to disconnect on this file.
Thank you.
Thank you,
Thank you,
John.
Judge.
Sir, can you tell me your name, please?
Jeffrey Culbertson.
Oh, okay. We had your hearing set at 2:30, but we can go forward now. Did you want to proceed with your divorce case?
If we could, Your Honor, I'm sorry about that.
Okay. Yep, we sure can. Just 1 minute here. Let's see. People versus Culbert, or I'm sorry, this is Culbertson versus Culbertson, case number 2419562. Mr. Culbertson is now present by Zoom video. This is set for default judgment of divorce. And it looks like, looking at the file, Ms. Culbertson was properly served with the summons and complaint. She did not file any answer or otherwise defend. A default was entered on April 5th. She was provided notice of that default as well as the date and time of today's hearing. She did not appear at 2:30 either, and she's not currently in the Zoom waiting room. So we can go forward. Mr. Culbertson, I'm going to place you under oath, and then I've got some questions that I need to ask you. The questions I'm going to be asking are those that I'm required to ask to establish the grounds for divorce under Michigan law, okay?
Yes, sir.
You raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you. You can lower your hand. Mr. Culbertson, you filed a complaint for divorce in this case and you signed that complaint. Is that true?
Yes, it is.
At the time that you signed that complaint, had you been a resident of the state of Michigan for at least 180 days?
Yes, I have.
Had you been a resident of Otsego County for at least 10 days?
Oh, yes.
In that complaint, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true when you filed the complaint?
Yes, Your Honor. We've been separated for about 10 years now, so it's been a kind of a long time coming.
Okay. Are there any children that were born to or adopted by you during the marriage, or were there?
Nope, there was nothing like that.
Okay. To your knowledge, is Miss Culbertson or Miss Sims currently pregnant?
No, she isn't.
Okay. And looking at the proposed judgment of divorce, you understand you would not be receiving any alimony or spousal support. You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that?
Yep.
All right. And you and Ms. Culbertson or Sims, you've already divided up any assets or debts of the marriage. Is that true?
Yes, it is.
All right, the court finds that the statutory grounds for divorce have been met by the testimony of Mr. Culbertson. The court will grant that divorce. I've signed that judgment, so copies would be available here for you at the courthouse for your records.
Thank you very much.
Yes, did you have any questions at all?
Nope, you answered everything I needed.
Okay. All right, very good. That's all for today's hearing, and you're free to disconnect.
Thank you. Yes.
All right, we'll go on record in Jones versus Munson Medical Center, case number 2319251. That hearing was supposed to take place at 3:15. Neither party appeared at 3:15. It's now 3:30. For that hearing, that was a motion to compel discovery based on the non-appearance of either side, including the moving party before. We'll simply consider that motion withdrawn. Okay, Mr. Roll, I'm just waiting for the other party to connect on the 3:30 hearing. All right, sir, can you unmute, please?
There you go. Did that work?
Yes, can you tell me your name?
Michael Adkins, Michael D. Adkins.
Okay, all right, we're on the record now in People versus Michael Adkins, case number 032969. Mr. Adkins is present today by Zoom video, as is Mr. Rolla on behalf of the people. And Mr. Adkins, this is your application to set aside 2 convictions from 2003, one for police officer fleeing and eluding 4th degree, and one for operating on a revoked or suspended license.
Okay.
Mr. Rolla, in terms of the technical requirements, I did get a notice from the Attorney General's office that indicated, outside of a potential issue on the suspended charge, that they believe that he has met the technical requirements. What is your position on that?
I don't necessarily agree with that, Judge. The other problem that people had is, and it's why I asked the court earlier, and for the record, my on behalf of the state, is we didn't have a hearing time scheduled for the notice. We did get the application, as I understand it, but that would be a technical violation, but I don't think that we're here. So, I mean, I don't know that that's much of an issue.
Okay. All right, Mr. Adkins, at the time that this occurred back in 2003, did you have a commercial license endorsement, or was it just a regular?
I think I might have had a chauffeur's license at the time. I'm almost 49. I think that was when I was like 28, but I think I worked at Asplin before that, and I would have had a chauffeur's license, I believe.
Judge,
all right, but yeah,
it was an operator's license at the time, as far as I can tell by the charging documents.
Yeah, okay.
And I say that not based upon any personal information, because again, this goes back to 2003, 2004, but the charging document that I pulled up from our files does indicate while his operator's license was suspended or revoked.
Okay. But
probably my driver's license. Yeah.
All right. So during that time, or when you were charged with that offense, you weren't operating a commercial vehicle at the time, were you?
No, my vehicle, my personal vehicle, my car.
Okay. All right.
Yep.
So the court finds that you've met the technical requirements. So there are two other requirements, Mr. Atkins. One of those is that your behavior and circumstances since these convictions would warrant having them set aside, and that it would be in the public interest or public welfare to set aside these convictions. And so those are the two things that you need to be able to address for me, because I have to find that those two things exist.
Okay.
So can you tell me about your behavior and circumstances since this occurred in 2003 that you would warrant having these set aside?
Yeah, those I think were in my late 20s. And then 14 years ago was the last time since then that I got in trouble, and it was for marijuana. But I had my medical card, and then I ended up getting 4 weekends in jail and 2 years probation, but they let me off after 9 months. Judge Wilson in Jackson is the one who did that. And then I paid 2,100 in fines, but since then I've never been in trouble again.
Okay.
Yeah. And then since then, I've also, I don't know if it matters, but so I've got a construction business, and I apologize with what I'm wearing. I'm actually at work right now. That's why I got my work shirt and stuff on. I apologize. But because I seen the thing on the screen that said proper attire, and I'm like, I'm at work. But I've been super blessed with construction business. I own a construction business here in Spring Arbor, Michigan, west of Jackson. I got a nonprofit here working with kids and families called Let Us Be Light. And so I started that, and I've also 2 years ago become an ordained minister. So I do a lot of evangelistic speaking in churches, stuff like that. But I've pretty much reformed my whole life from years ago, which that's what I use my life for an example. And then this came about because I got called for jury duty, and Judge Wilson, who 14 years ago, the last time I was in trouble, I was in front of him. One of the questions as a jury duty was something to do with being sentenced in his courtroom, that prosecutor. And then I brought it up to him. I said, well, Your Honor, you're the one who gave me that big break, back in 2010. So he laughed about it. And so I wasn't able to be a juror. And he's like, Mike, why don't you go down to the library? They'll help you do it and get those expunged. I'm like, well, I've thought about it, but I really don't know how it works. And he's like, I'm telling you, go to the library. They'll help you, with what I've done in my life, blah, blah, blah. And I said, okay. So I left there, went down, got the printouts of my stuff, went to the library, and they've been helping me work on this stuff. But yeah, I'm a single dad, raised a kid, my son from a baby, just graduated Western, one of the top schools here. Totally different. That was, like I said, in my late 20s. I was a wild child then. Complete different person, thank God. I've been super blessed since. But now I'm with my nonprofit, Family Services in Jackson, are the ones who asked me to start to work with kids and families, but I told them it's not a possibility. I have a felony. They kept saying no, blah, blah, blah. And I'm like, no, I promise you I do. There's no way I can, because I coached football and soccer here for Jackson too, work in Dibble School. And then all that stuff came out about the felony. Well, then Family Services, I was with them, and they told me to start this, and I told them I couldn't. And they said, no, you become your own entity. You don't work for the state. And that's how my nonprofit started, was Family Services asked me to do that. And that's how that all became. But anyways, whole different person, whole different life, been super, super blessed in life. And Judge Wilson told me I need to go do this. So I thought might as well, it might open up some other doors and other opportunities for me, which Lieutenant Coburn runs the Channer Road facility here in Jackson. So I'm working with him right now to start a jail ministry. So he's talking to the captain in here, which then I talked to the captain because I didn't know. I was hoping. I grew up north, up by Gaylord. I grew up in Atlanta and graduated. I was going in the military, came down here, was at my aunt's waiting to get my physical, busted my hand. They PMR'd me. So I got stuck in Jackson County. Well, not stuck, but I stayed down here with them. Ended up in the wrong crowd, wrong scene, ended up a wild child through my 20s. I was never that way in Atlanta, growing up and graduating, but got the city life here, did all that wild stuff. And then, so that all failed for me. So now that I'm working on the jail ministry, I actually called the captain here in Jackson to see if once these felonies, if possible, if they do get removed, can I even get into, I've done construction. I have a construction business called All Your Needs. From the home to your trees. I do tree stuff too, but right now I'm on a new construction site. But I asked him, is it possible now, if I get these expunged, I was talking to the captain, can I go into law enforcement or corrections now with these gone? Which then he told me I'd have to contact, I think it's called MCOL, the state guidelines do that. It's not them. So I told him I'll wait, see what happens, what goes on with this. If so, that'd be super great blessing. And if not, I mean, I completely understand. I committed the crimes back then. So it's not that I don't understand. I'm just, you know, just hoping things will change and keep getting better. Life's been good. I've been super, super blessed. And I just don't know if this was that happened because maybe there's some doors that are supposed to be open to me. And this is part of the process. I don't know. I don't know where life's taking me. So I just thought I'd try with you guys and see where it goes. You know what I mean?
All right, okay, thank you. Mr. Rolla, do you take any position on whether the court should grant the relief?
Well, Judge, first off, I'd suggest that Mr. Atkins take his hat off.
Oh, I'm sorry. I'm at work. I apologize.
Oh, not a problem.
Actually, I didn't even really notice that. I was, okay.
I'm sorry.
I'm in a sense, it makes he presents better with the hat off. In any case,
And I should have done that. I apologize.
the only issue, of course, is, as Secretary of State brought up, since you have driving offenses, you have that issue that they may be on a non-public file, but they wouldn't be completely removed from his record. And I just wanted Mr. Atkins to be aware of that if the court's going to address it.
Gotcha.
All right, so Mr. Atkins, after listening to what you've had to say, number one, I do find that your behavior and circumstances since these convictions would warrant having them set aside. You've gone a significant amount of time without having any kind of involvement with the criminal justice system. And it sounds like in terms of raising your family and moving forward with your career, you've done the kind of things that everybody expects to do during their time. So I find that requirement has been met. I also find that it would be in the public interest to set aside these convictions to the extent that you want to pursue different aspects of ministries or being involved with. The court finds that it's in the public interest that we don't have enough people willing to do that in the first place, and for you to be prevented from doing that based on a conviction from 2003, over 20 years ago. And a conviction which I know would not give the court any kind of concerns about you working with children. It doesn't have anything to do with kids and wouldn't provide an indication that you would be a danger in any way. So the court finds that it is appropriate to grant that relief. And so I'll sign this order today. If you need a copy of this for your records, Mr. Atkins, you can contact the clerk's office here in Otsego County, okay?
Awesome. Thank you so much.
You're welcome. Do you have any questions at all?
I sure don't. Thank you very much, though.
Okay, very good. That's all for today. And all parties on this file are free to disconnect at this time.
Very good.
Okay, thank you, Hunter. Thank you. Out there. I'm swiping.
All right, Mr. Bryant and Miss Bryant, were you able to reach any kind of agreement?
Yes.
Okay. So what's going to happen with that then?
Him and I agreed for him to pay $1,295 when he gets his bonus in November, his bonus from work.
Okay, and Mr. Bryant, do you agree to that?
Yes, sir.
Okay, I'm writing this into the judgment. And that's a credit card debt, Ms. Bryant?
Yes.
Okay. Okay, so I've written that in. And other than that, there are no other disputes, correct, Mrs. Bryant?
The only thing that I asked of him was by the end of the month to be on his own auto insurance and his own phone bill, and he agreed to that.
Okay. Mr. Bryant, is that correct?
Yes.
Okay. All right. And you don't own any real estate or real property together, is that correct?
Not together.
Okay. All right. Mr. Bryant, do you recall those questions that I asked Ms. Bryant at the beginning?
Yes.
And did you hear all of her answers to those questions?
Yes.
Do you have any reason to believe that any of the answers that she gave were not true?
No.
Okay. And you also are not going to receive any alimony or spousal support. You would also be forever barred from that and would not be able to come back later and ask the court for that. Do you understand that?
Yeah.
Okay. All right, the court finds that the statutory grounds for divorce have been met by the testimony of both parties. The court will grant the divorce. I've signed that with today's date. Ms. Bryant, you're asking to have your last name changed, is that correct?
Yes.
Okay, so going forward from today, your last name will be legally changed, so you'll need to make sure that you change your identification and other documents, okay?
Okay. So that will finalize the divorce today.
Correct. The divorce is final as of right now. If either of you would like a copy of that judgment for your records, you can get a copy from the clerk's office here in Gaylor.
Okay.
Ms. Bryan, do you have any questions?
What do we do? Like, is there anything else that we need to do going forward or any other court dates or anything?
No, today is it.
Okay.
Mr. Bryant, did you have any questions?
No, sir.
Okay. Thank you. That's all for today. You're both free to disconnect at this time.
Thank you.
Thank you.
All right. I'm just waiting for it's like Mr. Norton to connect here. Okay, we'll go on the record now. This is TBF Financial versus 45 Degree Hospitality and Dean Bach, case number 2319505. If I could have both counsel put your appearances on, starting with plaintiff, please.
Good afternoon, Your Honor. Daniel J. Fico, P58733, appearing on behalf of plaintiff TBF Financial.
Scott Norton on behalf of defendants 45 Degree Hospitality, Inc. and Dean Bach, P35717.
All right, thank you. We're on the record here today for two purposes. Number one, we have plaintiff's motion for some partial summary disposition as to defendant Dean Bach. And then also a status conference. I'd like to address the motion first. I did have a chance to review the motion in brief and the supporting documents, as well as Mr. Norton's response and the exhibits that he submitted with that. So I'm aware of the basis for the motion. Mr. Fico, is there any oral argument that you wanted to present in support of your motion here today?
Your Honor, I'm more than content to just rest on the submissions, just to reinforce plaintiff's position. Based on the materials that were provided in discovery and that were furnished in response to the first motion for summary disposition, those documents which are being preferred to show that this debt had somehow been satisfied or paid relate to an entirely different agreement, a different piece of equipment, a different time, a completely different transaction. There's been no further documents produced in discovery, which is now closed. So I think the court can fairly infer from that there is no documentation there in the possession of defendants that could be used to show that this debt has somehow been settled or satisfied. So we would ask for summary disposition on that basis.
Okay, thank you. Mr. Norton?
I too can primarily rely upon the response, which included the answers and affirmative defenses, bringing forth the issue of payment and satisfaction, the discovery responses at interrogatory number 5, attached as Exhibit B, and the request to produce number 1, where we produced records not only from Huntington Bank, but Teoma itself. Teoma Judge was the underlying agent that performed the work which plaintiff is attempting to impose on 45 Degree and Mr. Bach. But that documentation, in fact, Mr. Fico's comments essentially create an issue of fact. He says that those documents don't somehow, by just you reading them or his interpretation, say that it wasn't paid and it involves something else, even though it was the same contractor. There were two different pieces of work that were to be performed. And so right there is a question of fact. And then we also provided a second affidavit and counter affidavit as their allegations of damages. And you know, given the standard of review, Judge, and I like most favorable to the non-moving party, which is Mr. Bach in this situation, we've met the burden under the case law cited, Nurmacher. We've done more than just make mere allegations. We've supported it by sworn testimony, 2 affidavits, bank records, records from Teoma themselves regarding invoices. And so we should be able to pursue our defenses and proceed with this matter forthwith.
Okay, thank you. Mr. Fico, it's your motion. Any response that you wanted to make to Mr. Norton's points?
I would only add that the affidavits are untimely. The court rule clearly requires that if you are going to dispute the legitimacy of the signature on a written instrument, such as the guarantee document at issue here, that affidavit has to be filed with the initial response of pleading. There is no contention that was done. That affidavit did not appear until well after filing of the answer, it was only appeared in response to my original motion for summary disposition, so it is not timely.
If I may respond?
Yes.
At the court, if you look at the court roll, it gives the court discretion with respect to that affidavit, but it's preambled by the fact, and as briefed, we still don't have a legible contract, Your Honor. I implore the court to look at the complaint, look at the first motion, look at the second motion, and look what was attached as the alleged contract. I mean, if you've got a different version than me, all you have to do is look at what you've been provided. I can't read it. There's probably other affirmative defenses, including signature and the like. I mean, what about issues of, waiving jury? What about arbitration? Attorney fees? You can't read it. I can't read it. Well, if you can read it, you're better than I am, but I can't read what has been attached. And as I put in my response, I would like an opportunity, even though our status conference order from April 1, an opportunity to file a motion under C8 to dismiss the complaint and or adjoin Mr. Bach with 45 degree on the stay.
All right, thank you. Mr. Fico, again, it's your motion. I'll give you the last word.
Appreciate that, Your Honor. I'll admit the contract is not the exhibit that we were provided from our client is not a great copy, but it's by no means illegible. It is certainly readable. It may take a little effort, but it certainly can be read, and the material parts of it are certainly very clear. Things like the amount of payment, the term are in very bold, very large font. It also very clearly states that there is a personal guarantee. That is also that document, the guarantee document is very clear, and there's no dispute about that the guarantee document, which is really what is at issue here. There's no dispute as to its clarity or the signature thereon. The only dispute is as to the underlying contract, which again is just not a pristine copy, but certainly readable with a little bit of effort.
Okay, thank you. So again, I'm not going to go back and forth, Mr. Norton.
Okay,
sorry.
understood, Judge.
I think you guys have said all you can say about that part of it. And frankly, I think I've got a hold of this issue anyway. As the parties have indicated, and both sides correctly enunciated the standard for review of the court under a motion pursuant to C9 and C10, and the court adopts those as the standard that the court is applying here today. And of course, when it comes to potential questions of fact, the court is required to view all the documentary evidence in a light most favorable to the non-moving party, in this case, Mr. Bach. And first, I guess, addressing the kind of the C9 portion of this, or the failure to properly plead the defenses. Number one, the court finds that those rules are in place to provide notice from the plaintiff side in terms of a C8 motion, put the defendant on notice of what the claims are and the legal basis for the claims. From a C9 standpoint, to put the plaintiff on notice of any affirmative defenses and what those are. And so from that perspective, the court finds that the pleadings were adequate to the extent that they weren't. Just as with a C8 motion where the court has to give, unless it would be futile, has to give a plaintiff an opportunity to amend a complaint. I think that the court would equally have to give the defense here an opportunity to amend their affirmative defenses to comply with the court rule, as opposed to simply dismissing or granting the plaintiff summary disposition on a technical or procedural matter. But the court finds that in looking at the pleadings, they're adequate to advise the plaintiffs of what the potential defenses are, and certainly Mr. Norton laid those out in his response to plea briefs, both for this motion and prior. in terms of the question of fact, again, viewing it in the light most favorable to the defendant, Mr. Bach, the court finds that they're, yeah, I agree with Mr. Fico. It's not a great copy, but I think with some effort, I think you can make out the terms of the lease, and certainly you can guarantee. So I don't think that's necessarily an issue. However, I do think there are questions of fact here. I think when I was researching this motion and considering the ruling today, I found myself having to make decisions about what I thought those documents meant. And when the court starts engaging in that, that's an indication that there is a question of fact here, that a fact finder would have to make those determinations. Also, Mr. Bach's argument, that the signatures is just a basic cursory, looking at the documents, the signatures between the lease and the guarantees do appear to be different. So I think there's a question of fact there, and Mr. Bach is disputing that he signed either or both of those documents. So the court finds that there are sufficient questions of fact here that have been supported by documentation as required under the court rule, to the point where the court is unable to say that as a matter of law, those defenses are so clearly unenforceable or unmanageable from a C10 basis that the court would grant summary disposition in this case. So for those reasons, the court finds that summary disposition is not appropriate at this point under C9 or C10, and the court will deny the motion. Mr. Fico, if you would prepare an order that reflects the ruling of the court and submit that under the 7-day rule, please. And then with regard to the status conference, I don't know if in light of the ruling today, if counsel, if both of you want to have an opportunity to speak to your clients, they can set this for a status conference in 30 days, or we can go forward from here today. Mr. Fico, from the plaintiff's side, how do you want to proceed on that part of things?
I don't have anything to take back to my client. If there was some kind of an offer or proposal, I would certainly appreciate some time. But I don't have anything at the moment, unless there is something right now that the defendants want to propose. But other than that, I don't know that there's any benefit to setting another status conference.
Okay, how do you want to go forward, Mr. Fico, in terms of scheduling with this matter? Recognizing that one of the defendants here is subject to a receivership.
Well, I understand. I don't dispute that the entity defendant is subject to the stay. So that certainly would remain in place. But we would just as soon proceed as to the guarantor defendant. I don't. I'm not aware of anything that would give rise to a stay against Mr. Bach. And certainly the time to raise that has passed. The stay order very clearly only refers to the entity. So no dispute about that. But as far as the guarantee liability, we would proceed.
All right, Mr. Norton.
Yes, Judge, several points. I hold in my hand a handwritten status conference order from April 1st indicating discovery to remain open for 90 days. That's now closed as referenced by Mr. Fico. Set for dispositive motion and cut off 120 days. That ended on July 31st. Set for status conference, which we're essentially conducting right now. And I'd like to bring up a couple of things. You mentioned about amendment of pleadings. I intend, if the court will permit me, to file a C8 motion regarding the contract. I also intend to file a motion to have Mr. Bach joined in the stay on the basis of the allegations at paragraph 18 of the plaintiff's complaint, where they bootstrap the guarantee to the illegible contract, and therefore would like the court to consider not only, well, whether, number one, dismiss the complaint and start over when they can find something we can read, or two, permit Bach to be encompassed by the stay that the court has already imposed against the co-defendant 45 Degree. And just a little bit on that, 45 Degree is the corporate entity, correct, but he's only a 50% owner, and we can't get access to information and the like because the other 50% owner is in litigation with us. And so I would like an opportunity, and I see no prejudice or harm or foul, that if we stay the proceeding, one, dismiss it, or two, if we stay it until the receivership order, which I'm the attorney in that matter, and it's about selling property, and we may have sold the last piece, that we stay the matter until we can get both parties involved and we can get a legible contract. So I would like to amend the status conference order to allow further discovery and to allow for an extension of the deposition cutoff.
So the motions that you're talking about in terms of a C8 motion and a motion regarding, a stay, why are we, all of that could have been addressed within the guidelines set by the court. Those aren't new issues. So why have you not filed motions until now? Why are we extending things out? You've had since April to file either or both of those motions.
Well, our primary focus was with respect to the first motion for summary disposition, which the court denied. Now we have a second motion, or what's called a renewed motion for summary disposition. We were not able, to be able to focus on that, on the stay with respect to Bach while we're defending motions for summary disposition that would have imposed a judgment against him personally. And
yeah, I mean, to me, that makes it more important for you to get your motions filed and heard, right? I mean,
well, okay, if the court doesn't want to permit the defendant to seek to include Mr. Bach in the stay, which I think there are legal grounds for that, and it should be briefed and heard, then we will, now that this motion, second motion for summary disposition being denied, we will then proceed to defend. So then the C8 motion is certainly within bounds, given the illegible contract. You mentioned something about amending pleadings. Plaintiff can amend their pleading if they can find a contract we can read, and then defendants can bring forth amended answers and affirmative defenses. And then we start all over again.
Yeah, I guess I'm just, I'm looking for a reason why you've been talking about the illegible contract since our first hearing. And, I set a 120-day period for dispositive motions. I'm still not understanding why you couldn't have filed that motion and we could have already had that heard. I'm looking at it from the standpoint of I'm issuing scheduling orders that set deadlines, and then, you're not following those deadlines. I have an interest in making sure my scheduling orders adhered to. So that's where I'm coming from.
Well, C8 says that you can file at any time unless there's a scheduling order. Then it's at the judge's discretion, this is where we're at this very moment. But I had already won on a motion for summary disposition and now had to defend a second motion for summary disposition. So when you talk to me about why we didn't file that C8 motion, out of the gate, well, we didn't have that opportunity, quite frankly, as we're defending two motions for summary disposition. And what prejudice does it serve any that is going to be against any party if you allow X number of days for me to file my C8. If they can produce a contract that can, I mean, I put the case law in my brief in this one, and you'll see it again if you permit me to file. But how can we go forward on this case without having the underlying contract, which they bootstrap the guarantee to, which you can't read? I'm asking, Judge, have you've got 3 copies of that contract in your file, and I don't know if you can read it. I certainly can't. And there could be other defenses in there that are available to us. What if there's a provision in there regarding arbitration that we don't belong in this court in the first place?
Okay, all right, I've got it. Okay, so what we're gonna do is, and I know, Mr. Fico, you're not stipulating to this, but the court's gonna order it. I'm gonna give Mr. Norton 60 days for you to get any additional motions filed. And I just want to be very clear that if you don't get those motions filed, I'm going to consider them waived because you've had 120 days to get them filed. The court's going to give you another 60. If they're not filed, then you're going to miss the vote on that. So I just want to be very clear here for the record that I do take my scheduling orders seriously. And I'm not hearing anything from you other than you didn't have time because you're defending these motions to file your motions. And I don't find that to be a convincing argument because I think you're more than capable of filing your own motion while at the same time defending plaintiff's motion. But that's neither here nor there. I'm going to put in a status conference order here that defendant Bach to have 60 additional days to file any dispositive or other motions, and then we'll set it for another status conference following that. And I will get that out to the parties in a written order.
Point of order, Judge. Is that 60 days filed and heard?
60 days filed and
Thank
days
you.
set. Yep. Okay. All right. Mr. Fico, anything further from your side today?
Nothing further, Judge.
Okay. Mr. Norton.
Nothing further. Thank you, Judge.
Okay, thank you. That's all for today. All parties are free to disconnect on this file. That also